This is always an interesting time on day 2 of a 2-day conference to see if people are showing up on time. But in any case, we're starting on time. So welcome. My name is Andy Butt, and I'm a director with the ADR Institute of Canada board. I'm pleased to be the room host here today and to introduce to you Christine Thomlinson, who's going to tackle the topic of workplace investigations, today's complexity and risk. Obviously a very current and lively topic for those of us that do workplace work. And Christine is a co-founder and a managing partner of the firm Rubin Thomlinson, which was recognized in 2016 by the Canadian Lawyer magazine as one of the top 10 labor and employment law boutiques in the country. With over 20 years' experience, Christine is considered a leading authority in the area of workplace harassment, workplace investigation, and workplace reviews. She's also a best-selling author and a popular seminar leader. And just from my own experience, it's worth having that book on your library shelf. You never know when you might actually just need a refresher on, okay, what's this all about? So thanks very much for accepting the invitation and looking forward to the next hour and a half. A reminder, you have the evaluations. They're critical to the planning, and we hope that you'll make sure that you fill them out and leave them on the back table or back chair on your way out. Okay, thanks very much, and welcome, Christine.
Thank you. Thanks so much, Andy. Don't go running and buying the book right now, because I spent the summer working on the update to the book. So just wait a few months and you can get the update, all the new stuff. But we'll talk about a lot of that today. So I was reflecting as I was preparing for today and thinking about the very first investigation that I ever did. And it was in my first year of law practice. And you could this probably won't surprise you, I had a client who called and said that they had this complaint that had come in and they decided they needed someone to investigate it. And could I do it? And like any good, overly confident lawyer, I said, of course. Never done that before, but of course I can do that. And I headed off to this out-of-town place to do an investigation, no idea what I was doing. And I found a book. The book was a very teeny tiny, actually it was more like a brochure that said, all you have to do is interview the complainant, the respondents, and witnesses and write a report. That was the substance of the advice and the sort of literature around this area at the time. I yearn for those simpler times, I tell you. So things have changed. If you're at all familiar with the work that our firm has been doing over the last several years, you'll know that we've worked on some high-profile cases involving the CBC and the Canadian Olympic Committee. And there is something enormously terrifying about doing this work under a public microscope, doing it in the public eye. But that being said, it really is an extraordinarily unique perspective that you do have when you've been able to approach the subject matter in that venue. So that's really the perspective that I'd like to bring to you today and give you a sense of really how the world of workplace investigation has changed. So when we talk about investigations and today's complexity and risk, I am going to be approaching it more from the perspective of the kinds of cases that we're working on as a firm, and we recognize the fact that people do come to our firm because of our experience in these issues. So we've characterized that in a somewhat unique way, calling those the high 5 investigations, and I'll give you a little bit more information about what those are in a moment. But that's, we're not going to be really talking about the very simpler, easier, kind of non-complicated investigations, many of which exist, and we know this because many of our clients do those internally within their organizations. But my sense is that to the extent that you might be touching on these issues, it's because you're being approached, given your unique expertise, with some of the really challenging workplace issues that organizations are confronted with. So we'll talk about those. I want to give you a little bit of a sense of what the legal landscape is like, because we've seen an enormous explosion in treatment around workplace investigations, both in the case law and in legislation. And then I want to wrap up our discussion today with talk around how ADR can be used as a tool around the investigation process. We're a fairly small group, and my style tends to be pretty interactive, so please, as we go along, if you do have questions, don't hesitate to raise your hand, and happy to keep the discussion as between all of us. All right, so the high five investigations, what do we mean by that? So just to give you a little bit of a sense in your own mind of the kinds of cases that we're talking about, I just want you to think back just over, I don't know, the last 12 months, just whatever's kind of recent in your mind, and think of the cases that have come to your attention in the media, through your contacts, and I want to get a sense of how many of you have heard of a case that involves some of the kind of behavior we're going to talk about. Okay, case involving derogatory language. Remember hearing about a case involving derogatory language? Okay. What about sexualized banter, jokes? Yeah, lots of nodding, good. Yelling, swearing. Unwanted sexual attention. Work with me. Degrading or demeaning treatment. How about non-consensual sexual relations? See, like a week ago, you might not have thought of all of those, but Donald Trump's taking care of the whole list. It's amazing. Good for him. But, you know, the amazing thing about this area is that it literally seems to be every couple of months we do have a new case that hits the public consciousness dealing with this kind of material. It's quite extraordinary. One of the things I want you to think about now is when that case was brought to your attention. And think more here from the perspective of the organ. So you have to put Donald Trump out of your mind. I know that's hard, but put Donald Trump out of your mind. And think about those organizations that were brought to your attention because you learned that this behavior was occurring in those organizations. So how many people remember having a thought to themselves at the time, how did they not know? How did they not know? Do you remember thinking that to yourself? Yeah, and of course, what we then subsequently read and heard about in the media was how did they not know, right? The public treatment, the sort of public judgment or scorning of these organizations because these issues were going on and somehow the organization wasn't aware or didn't deal with it. So that is really the landscape in which we're operating today. And, you know, there's a whole lot of theories as to why that is. I think social media plays an enormous role in how these issues have developed and really come much more into the public consciousness. But it does mean that we're often dealing with, at least in our consciousness and in the public, we're dealing with issues that are much more serious. So that's why when we talk about the high five, we're really talking about the ones that are significant enough to come to our attention, to come to the public's attention, and we've broken them down that way. So high five, we're going to talk about each of these. What distinguishes them from what might be a fairly innocuous complaint that gets raised in an organization that's investigated on a low-level basis and gets addressed kind of quickly and easily, is that these ones really are the most complicated, most layered, the most interesting, if you're in our line of work, I suppose. But they're also, for those people involved, including the people who are investigating them, the most stressful and the most demanding. So let's just talk about each of those in turn. Starting with high impact. So here we're talking about cases where the allegations are, it can be a number of different reasons, but overall where the impact of the behavior that's occurring has been or can be extremely significant for the organization. So it may be that the allegations are extremely serious. It may be that the impacts of whatever has happened in the organization or what's happened that's the subject of the complaint has really, the tentacles of it have reached out into the organization in many ways. Somehow the whole organization has been impacted by these behaviors. And it may or may not be related to broader workplace culture. So when you talk about seriousness and layering, it really is not a conflict that's confined to a limited number of people, which operates in isolation in an organization. These kinds of cases have far more reaching impacts. The organization almost feels them viscerally. And for those of us who investigate them, it really is, it's one of the stresses with these cases, because when we talk to the people in the interviews that we do, we really hear and experience the pain and the impact that the behavior has had on their day-to-day experience. So, you know, important to recognize that those cases are out there. It's why, no doubt, when they come up, we do hear about them in the public forum. But it's also why, as investigators or as ADR professionals, when you get called in to try to assist in those cases, you recognize the impact that that's going to have and how significant that's going to be. You know, one of the things that we've talked about, certainly as a firm, when we get retained on cases like this and we anticipate how those interviews are going to feel and all of that, you know, I often think about the analogy of when I do investigations, I feel like a little bit of a sponge. You know, I absorb all of the emotion that people communicate to me in the course of the interviews, and then I have to kind of live with that while I'm working on the case and until I can report, and then at the end, you know, I can release all of that back and let it go. But for that time period where I'm holding it in, it's extremely stressful. And my family's actually gotten to the point where they just can tell that I'm doing a difficult investigation because I'm completely distracted. They talk to me and I'm not listening, and, you know, they can't kind of get my attention. So knowing that, I think, is important. And you know, these are the kinds of cases that we do frequently, so they certainly happen more often. So high impact, and then high demands. So high demands relates more to the experience of the investigator working on the case. So it may be as simple as having a very demanding client. And sometimes the clients aren't demanding because the case is necessarily complex. It may just be it's the first investigation that they've done. They're not terribly familiar with the process, and so there has to be a lot of hand-holding and a lot of managing of their own emotional experience of what they're going through. And I'm thinking about a case that we actually are doing right now, which is a very, you know, it's not an insignificant case, but it's a racism allegation, so, you know, it's high intensity for the organization. From our perspective, it's not something we haven't seen many, many times, but for this small not-for-profit, it really is kind of impactful for them that somebody in their team is being accused of being a racist. And so they're, you know, really high emotion about this. And I know this because on Monday, we'd probably been retained about 2 weeks ago, and the Jewish holidays were in there, so there was some time lags associated with people not being available on given days. And I got a call from the client on Monday this week, so we're about like 10 days from being retained. And they said, I don't understand why these meetings haven't happened yet. It's been 10 days. And I'm thinking, really? Because like 10 days in my world, that's not such a big deal. But okay, let's just relax and think about this. We'll talk about perspective. So high demands in terms of where the client is coming from. High demand can also often relate to how the investigation ends up unfolding. And so one of the things that we see quite frequently is what appeared on its face to be a straightforward, somewhat uncomplicated case. Maybe it's one complainant, one respondent. There might be a handful of allegations, morphs over time into something that becomes far more complex. And that places huge demands on the investigator and on the client, because they have to manage time, they have to manage all the people involved, and mostly they have to manage the process, because the process, and we'll talk more about this when we talk about the law, but the process is really what's coming under a lot of judicial scrutiny. So I'll give you an example. I'm somewhat embarrassed to admit that I'm still working on this case that started last July of 2015. And this was a case that when it started was the complainant alleging, between the two of them, there was about 25, close to 30 allegations for 2 respondents. So it was fairly big in its original presentation. So I met with the 2 respondents, and one of the respondents said, well, I have a complaint against her. Okay, so now we've got a counter complaint. Only 1 allegation, thankfully. So I met with them, and then I started to meet with the witnesses. And as I met with the witnesses, what became clear was that there was not a complaint per se, but that there were allegations that they were telling me about, things that had happened, which, if true, the complainant had done, which were all violations of their policy. So I went back to the organization and said, look, this has been brought to my attention. You know, I need to make sure you're aware of it, because if it's true, it's happening in your organization, it violates your policy. You tell me what you want to do. And they said, well, I think you need to investigate that as well. So we had to convert those additional allegations into effectively another complaint back against the original complainant. And of course, when she found out about that, she said, oh, well, now I have a complaint against one of those people. So we were now into the 4th complaint back, and so she had a whole new set of allegations against one of these people. And I've just, within the last month or so, learned that one of those people has 1 more allegation back against her. So it becomes, you know, just managing the process becomes extremely complicated. And, you know, anybody that's saying, oh my gosh, that's ridiculous, you know, there does come a point where you can say enough is enough, more is just more. But in today's world, you know, these are, in this particular organization, these are very sophisticated people, they're represented, and you can't just sort of decide not to deal with it, because if what they say, if true, would represent violations of corporate policy, they have a right to have these issues heard. So another high demand issue. As you can appreciate, those kinds of investigations put major demands on your time. You know, when I took on that case a year ago, it looked fairly uncomplicated. And one of the reasons why it's taken so long to do, part of it is the unique nature of this organization. There's periods of time where people aren't available. But also because, you know, I had a certain amount of time available when I took it on, and then when it became this big behemoth that it became, I couldn't necessarily give it full-time attention. So I've been kind of fitting it in where I can. And then you can see that one of the things we can now anticipate is where we do have multiple parties, where we do have many allegations. We just know how much demand is going to be placed on us, and how focused we have to be on these cases. Okay. High risk. So here, what we're referring to are cases where we can now often recognize at the beginning, just in the way the case presents to us at first, that there's a high risk that there'll be a legal challenge down the road. And so, not to say that we investigate those cases any differently, but certainly, you know, where we have judgment calls to make along the way about the process that we're going to follow, we take those calls extremely seriously when we have a sense that there's the likelihood that the case might ultimately end up in litigation. Or, interestingly now, and we'll talk more about this in a moment, under Bill 132 in Ontario, there's an ability that the Ministry of Labour will have to come in and look at what an organization has done, and recognizing that they could say, you haven't done enough, we're going to order a new investigation to be done. You know, these are all things that are going to really influence, not influence, as I say, how we're going to do the investigation, but just really cause us to pause and be sure. And in fact, one of the things that we'll do is in these cases where we can identify them early on, we'll first of all alert the client to the fact that if they don't see it, there's a good chance that the case might ultimately be subject to legal challenge. And then really encourage them to get their counsel involved early on, so that their lawyer is really thinking about, you know, what could this look like in court down the road? How could I argue that if this is the step we took, or if this was the judgment call that we made, that it was the right one? So I'll give you an example again. I was speaking to a colleague, a friend of mine actually, and she's doing an internal investigation in her organization. And the allegations in this case are extremely, extremely serious. Kind of allegations that, if they're found to be true, will destroy the career of one of the parties or both. And I think she knew that intuitively, which is probably why she was calling me to talk. She just needed somebody to kind of run things by. And she was reaching points where she was having to make decisions about how far down a path to try to get evidence, who to speak to, and she was struggling because she just, I think what was happening is in her mind she knew that this was a big deal, but she wasn't quite sure what to do. And so, we talked through some of the issues, but one of the things that I strongly encouraged her to do was reach out to the organization's lawyer so that she could get him or her involved and really have them be advising her on the kinds of calls she should be making. So, for example, one of the issues that had come up had to do with voicemails and texts that had allegedly been sent between the parties. So the complainant alleged that the respondent had sent these offensive messages. The respondent said, "I never sent them." It appeared that they were showing on her phone, but the respondent was denying that he'd sent them. So my friend said, well, what can I do with that? I can't do anything with that. I can't prove it. And we talked about, possible technological resources that she could try to access, maybe trying to get phone records. So thinking about ways that she could continue to follow that evidence down the path. And then with the addition of her counsel could say, if ultimately you're going to make a decision, the fact that you either didn't pursue that evidence, or if you did pursue it, you pursued it as far as things. We'll really, really try to unpack when we know that the case is high stakes. So here, what we're referring to is really a case where the outcome for the organization or for the people involved is going to be significant. And the one thing that you may have already realized is that these different categories aren't by any means mutually exclusive. So you can see in one investigation, it may be high impact, it may be high demand, it may be high risk, it may be high stakes, it could be everything. But some of them fall into unique categories. So here we really think about, what ultimately is this going to mean for either the organization if these allegations are proven to be true, and then what personal risk, it could be one or both, but what personal risk have people taken in bringing these allegations forward? So whether it's for individuals that there's a high stake, or whether it's for the organization there's high stakes. I think one of the things that we often talk about when we talk about investigations that people find to be quite radical, and particularly when we're talking about high stakes, it's amazing how people, complainants, sometimes present in these cases, because they've taken the extraordinary leap of deciding to come forward with an allegation. I'm like saying these words and I've got Donald Trump ringing in my head again. We had this amazing conversation at our dinner table last night with my teenagers, because we were talking about the fact that there were these women who were coming forward now after all these years, and my son, who fancies himself a bit of a lawyer in training, said, it's just one person's word against another. How can you possibly prove anything? And that was a whole other discussion. But the concept that people would have something happen to them and choose not to come forward for an extended period of time and then decide to come forward at some later time, for a lot of people is really tough to accept. And for a lot of people, the visceral reaction to that is to just intuitively disbelieve what they have to say. And for a lot of people who've experienced that behavior, they sure know that, because that's one of the reasons why they don't come forward in the first place. We did also have this interesting discussion last night about the fact that, coming forward back when a lot of those alleged occurrences were believed to have occurred, was a time when women they couldn't come forward about things like that. There was, and come forward against Donald Trump. What would possibly be the point? What would ever cause me to put my own personal reputation at stake at that point in time? We are such a different world today. And even today, you look at the thing that actually appears to have prompted some of these women to come forward. It wasn't his running for president. It wasn't, as the election got further and further along, it was really statements that he made that they took to be a personal affront given the experience that they had had. And that's not unusual. You know, when we talk to complainants who have come forward after an extended period of time, often it is something that's deeply personal that has caused them to decide that at that point in time they have to pursue it. I had one case a number of years back where a woman had worked in an organization. She'd been, it was culturally one of those organizations which is very sort of old boys club. Everyone's encouraged to go out drinking, and there's a lot of womanizing back in the day. How she chose to deal with that was she quit her job, and she went off and found another job where that was not the expectation. And she came back and complained a year later. And of course, the first defense that the two respondents said was, I mean, this is ridiculous. You know, obviously she's just trying to get money. Why else would she come back? And so I asked her, you know, why now? Why did you come back? And she said, I have 2 young girls, and I sit at the dinner table every night. I'm a single mom, and I look at them, and every day I can't live with myself that I allowed something like that to happen, and I didn't do anything about it. And every day I'm reminded that I didn't do it, and I couldn't live with myself anymore. I had to come back and do something. And I was like, yeah, that's compelling. That seems reasonable to me. You know, she didn't want money. That wasn't what it was about for her. So, you know, when we talk to people about why people don't come forward, and for me this has been kind of a humbling experience, because I always believe myself not to be that person. You know, if something happened to me, I would say something. I would speak out. And I recall early in my career having those judgments. You know, as investigators, we recognize we all come to this work with our own personal biases. And I remember having those judgments myself of people who said that they, or, you know, or I would hear in the case that somebody'd come forward years later, and I'd have a certain reaction to that. And so it's been such a learning experience to hear the reasons why people don't come forward. So just to share a snippet of them, because it's not an exhaustive list. People being afraid they'll lose their jobs. You know, I've had the privilege in my career to often have roles where I don't feel vulnerable the way that many people who work feel. And whether that's because, you know, they're new immigrants, whether that's because they don't speak English as a first language, whether that's because they live in poverty, you know, they have reasons for needing to cling to their jobs that I can't relate to. And so I have to open my mind and recognize that people come to the workplace with that experience. People who assume the company already knows. And sometimes those assumptions are false. But for whatever reason, they have got some information in their mind that leads them to think the organization already knows, and if they know, they would have done something, so why should I put myself at risk by bringing forward? Maybe they don't know how. And, you know, we've had a lot of experiences lately where we've been doing assessment work and gone into organizations, done surveys, heard people talk about their experience with a corporate policy, and organizations that have worked very hard on their policies that have like what they believe to be beautiful Cadillac policies are shocked to learn that the policies are not working the way that they thought they would or they should. And a lot of that goes back, you know, frankly, to training. You do the great policy, but then what kind of an effective job do you do at communicating to people how the policy works? I just worked with one organization that had come out of a lengthy process, had sort of identified through the process all the flaws in their policy, and the policy, you know, wasn't bad. It needed to be nuanced. But the big issue was that in this sophisticated organization, people just didn't really understand how to use it. They really didn't. And so what they decided to do was do sort of an e-learning training module. And I sort of heard that and was a bit skeptical. And I said, well, could I see the module just to get a sense of how you've tackled this issue? And the module didn't say anything about the policy. And I said, okay, well, it's great in familiarizing people with the conduct, but you know, the gap is that people don't understand your policy. You know, you got to fill that gap, or they're not going to know how to come forward when they have an issue. So there's that. There's the relationships that they have. You know, people, it's the funny thing about people in the workplace is they're human. And they have relationships, so they don't want to rat people out. They're friends with the harasser or the alleged harasser. All those things are at play, and again, you know, hard to judge because that's who people are. Huge issue is when they don't have any faith in the organization to correct the issue. Why would I put myself at risk? Why would I take this leap if I'm not confident at the end something will change? So, and I think, you know, and I've actually given this advice to organizations before, where we get called at the outset and they're looking to retain us. You know, if you're not prepared, we can project right at the outset that there's a possibility that this will be the outcome, right? That's what the allegations are. You have to wrap your head around the fact that if that's what you're looking at, you're going to do something about it. Otherwise, putting your whole organization through this process of an investigation is going to be enormously negatively impactful if you're not prepared to do something about the problem that you learn about at the end. So you're better off not to do it if you're not prepared to go there at the end. And then the bystander effect, something that we're hearing more and more about today, this belief that, you know, it's not my problem, I'll let somebody else complain about it. And I'm a bit, I have to say, gratified by the talk around that. You know, the Ontario government's been doing a lot of educating around that. We're seeing more training programs around that. And a real shift in, I think, the discussion in organizations from, and we'll talk more about this in a moment, from complaint-driven policies and processes where it's really very much about it's the person's problem as opposed to awareness-driven approaches. You know, it's not her problem or his problem because it's happening to them. It's our problem because it's happening to them. And so we all have to take responsibility for the fact that this is occurring, and we all have to commit to bringing it forward and addressing it if it's going on. So for sure, no one organization is insulated from any of these kinds of things. But we have found, purely in our own experience, I'd be curious to hear if it mirrors your own, that there are certain organizations where types of behavior are more prevalent. And in our experience, again, it's just the unique way that the organization is structured or the way that the environment is kind of allowed to exist that creates a bit of a warm, nurturing environment for bad behavior. So one of the cases, and I was on a panel once with a sociologist, doctor of sociology from U of T, and she talked about the fact that this was the biggest problem that she'd identified in her research was sexual harassment occurring in organizations when it's the boss who's the perpetrator, because really they answer to no one. And I said, oh, it's funny, I don't do many investigations in that environment because, like, why would they hire us? They're not investigating, they're just firing people who complain about things. So that's a problem. Sorry, Donald Trump is like, I'm hearing again in my mind. What if he runs the country? Oh my gosh. Okay, stop talking about him. Organizations, high stress, high pressure. So, you know, none of us are at our best necessarily when we find ourselves in that emotional place, and a huge percentage of the cases that we do, particularly ones that involve allegations of bullying or workplace harassment that's not human rights based, come up in those kinds of environments. You know, the tension causes people to act in a way that they wouldn't optimally if they didn't have to address those workplace realities. People with star power. Anybody come to mind when we talk about that particular description? Just read the CBC report. You get entirely what that talks about. You know, they're just, people believe that they answer to no one, everyone's afraid. And I will say, not remotely unique to that environment. That was a scenario, a workplace reality that we had seen repeatedly in different types of organizations long before CBC. And the ones that immediately jumped to my mind involved senior sort of financial people, senior executives, investment bankers, physicians, So, you know, all kind of God complex, I'm at the top of my game, no one's going to fire me, look how much money I make, look how much I'm doing for this organization. That kind of mentality allowed, you know, in many cases, behavior to go completely unchecked for extended periods of time. And people, you know, often who were on the receiving end were terrified to take on the big star. Organizations where you've got individuals with minimal supervision. So we'll often see this on, for example, the night shift, or there might be a remote location somewhere where people work kind of unobserved by others. So, you know, again, we say to organizations, if you know that you've got that dynamic occurring anywhere, that's something that you really want to be conscious of. Pay more attention to those areas within your organization, because that's a feeding ground for that kind of poor behavior. And then homogeneous groups. So if you've got groups of people working together who all look the same or who all are the same, the challenge there we find is that complaints come up when somebody enters the group who's not the same. So it could be a group of women where a man starts to work, could be a group of men where a woman starts to work. Our CMP comes to mind. But it could be, you know, a cultural group. You have, I did an investigation once where for some reason everybody who got hired was a particular ethnic background because they were all referrals, you know, so they were all friends and cousins who were getting referred, and all of a sudden the group looked very much the same. A lot of them were related, and then it really just took someone to come into that group who wasn't the same that created conflict. So just another thing to look for in terms of the most susceptible areas for this kind of behavior. Okay, and then lastly, high profile. So again, you've seen some overlap between the groups that we've looked at, but this is really the star power reference that we made. So where you've got either individuals within an organization who are high profile, you can anticipate right at the outset that the case is going to come under enormous scrutiny. It might be just within your organization, because it might be that all of a sudden, for example, the board of directors is paying attention where they wouldn't otherwise. It might be in your industry. It might be that there's a regulatory issue. But most concerning, most terrifying is, of course, when it's under the public eye, when it's become media worthy. And then for the organization, when the organization is high profile, you know, we see cases where it doesn't necessarily have to be about an individual in an organization, but the fact that certain behavior has been allowed to go on within a high-profile, iconic Canadian organization is newsworthy, and people pay attention to that. So those are our high five, and those are really the types of cases we work on. And, you know, my hope in being able to talk to you a little bit about those is that depending on how or if you've been involved in investigation work at all, if you've been doing some of it, if you've been kind of touching on it, or you might see or work with organizations where the need has come up, to be able to be aware that this is the new reality, that the risk that that investigations look like this is the new reality, I think is a really great learning for today, because not everybody knows that and is familiar with that. And the last word on that I'll say before we move into the law is that in some cases, and depending upon the amount of experience you can have a sense at the beginning that you've got a high five case. But in a lot of cases, it doesn't look that way at the beginning. And so it can look kind of simple, it can look kind of low level, and then before you know it, the snowball has headed down the hill and the thing has just blown completely up. And so I think that's an important takeaway as well. You know, again, if you're working with clients or they're seeking your advice, is just to help them understand that, you know, how we're going to approach this needs to potentially contemplate that reality. What would this look like if it got out of hand? How would we address it? Are we prepared for that? Okay. Yes, Rick.
Just a question, sometimes you'll get a situation where one way of putting it might not be the best way of putting it, but the way I'm going to put it, I think people understand, where you feel that you need to practice defensively.
Yeah.
But those of us who are professional lawyers know there's certain things you do that the client pays for, but they do because as a lawyer you're responsible to do it this way or to be considered negligent. And with an investigator, I don't different. If anything, I think it's even more relevant. So I'm often struggling with, if you get a client, you know, of not even modest means, just medium means, but as an investigator, you know there's a right way, and you know what's thorough, and you know what's not good enough,
Yeah.
and then you know there's a lot of gray areas in between. How do you deal with a client who won't or doesn't want to do it right, and yet you're in it already? Like,
Yeah.
you're not, you know, this is the retainer conversation. This is the halfway down it, and you're in it, and you're trying to get instructions. And I totally
Such a great
love
question.
the idea of dealing with their counsel, because their counsel's going to be as paranoid as I am.
More so.
Yeah.
More so. Yeah, and such a great question, so I'll just repeat it for the webcast. So the question was, as an investigator, when you recognize and when you recognize the potential need to behave defensively, to work defensively, and you see some things that your clients want to do or instructing you to do that might not achieve that objective, how do you handle it? So I agree. One of the things I'll often do is encourage them, if they haven't already, to involve their counsel. Because if there's two of us saying the same thing, it helps. And the other thing I will say is there's nothing that is more important than ours and your reputation as an investigator. So I won't do things that I think shouldn't be done. And we've been fired because of it, and we're completely fine with that. One of the things that comes up, less so now, but used to come up a lot, was our practice as a firm is that we don't ambush respondents. So our view is a respondent has a right to know the case that they have to meet, the allegations that they have against them. So we'll never go into a respondent interview and confront somebody with a set of allegations. And we've had clients that have asked us to do that, and we've refused because we don't think that's fair. We're not going to continue to do an investigation that's based on an unfair foundation. So that is a little bit different than other situations where it is more of a judgment call. And they're a little tougher. The respondent one we can usually deal with at the beginning because it's close to the time of the retainer, so we usually kind of cross that one at the outset. But one that comes up often is we'll get into the investigation and there's a path we can see that involves interviewing certain people. And, you know, you talk about balancing different interests, right? The client wants it to go quickly. The client wants it to be less expensive, so they don't want to go down the path. We don't want you to investigate. We don't want you to interview any more people. And if we disagree, then, again, we kind of practice defensively. And here we're doing it defensively for us, not defensively for the organization. And I've had conversations with clients where I'll say, okay, that's fine. But I want you to recognize that when I write this report, here is how it's going to read. It's going to read that I identified that I felt it was important for you to interview these people in order to draw this conclusion, if that's what you were asking me to do, that you were not prepared to have me do that, and that is why I could not make a finding. And it's amazing how just spelling that out for them has them say, okay, fine, interview the people. We don't want to read that report, because that's not valuable to us. If it's going to all of a sudden be couched in all these contingencies and caveats, that's not what we wanted. So it's tough.
Qualified opinion.
Absolutely.
Like a qualified audit. Sometimes it's nice, but it's not what the paper is printed on for the purpose that people have asked for.
Yeah, and they're in it, right? I mean, if you've invested this amount of time and money, you might as well get the thing that you set out to get in the first place. That, for us, almost always works. Yeah.
Question, on workplace investigations, they tend to be a little bit adversarial, right? So it's he said, she said, all the rest of it.
Yeah.
Have you ever had an occasion where you actually changed your hat midstream and said, I'm going to mediate this? This is not investigative work?
So I haven't personally, and I think I have been nervous about doing it. And I think the reason I've been nervous about doing it was I had one experience actually when I was counsel for someone on an investigation where the investigator did that and did it poorly. And it really, I thought, kind of sabotaged the process. Certainly it sabotaged the process because when the mediation didn't happen and the investigation continued, I felt that there was no way at that stage that the mediator could now proceed to do a neutral investigation. So I won't say I don't think it can never happen, but I think the risk always is that if you interrupt an investigation process and attempt to mediate it, I don't know how you take the information in that kind of confidential shell and then try not to use it as you proceed to now be the neutral investigator. Because ultimately the investigator has to make a decision, and you have to be really sure that you didn't get information in that process that you shouldn't be using.
Well, we do it in our lead all the time, right? So it makes sense to me.
Right, yeah, no, fair enough.
And then I guess the second part of that is fallout. So what is the environment like after you leave? Like, what is research, is there any research on this? Like, how do people go after that?
Yeah, so we'll talk a little bit more when we get to the end, but I mean, one of the real opportunities, so I want to go back and just answer your other question, because I think that there are all kinds of times when, and I've had many conversations with clients where we get into the investigation and I say, so I could finish and I could make a finding, and here's what that will look like. I'm not saying how I will decide, but it's going to be one of these two things, and here's what that will result in. And that's not great, right? Because people are so polarized, as you say, the adversarial nature is usually one party against another. All this is going to do is make one party emboldened and the other one more upset. So if there's another alternative that I can identify as I'm investigating, I'll absolutely bring that forward and suggest that we change direction. So I think lots of opportunity to have that in an investigator's mind, and especially for ADR professionals that are doing them, you know, the myriad of different options that are available. I think you can probably see those paths even better than a lot of investigators can. And then we'll talk a little bit later about how you can perhaps use investigation as part of the ADR kind of toolkit. Yeah, we'll come to that. Okay, so let's get a little bit of a sense of the legal landscape. And I didn't intend here to do an exhaustive review of the law, because it is astonishing how many cases now are talking about workplace investigation. When we did the first version of our book, which was published in 2006, we did a list. At that time, it was a fairly short list. It was an appendix, 3 pages, I think, of cases where we could find that investigations had been spoken about in a case. And we contemplated doing it this time, and quickly it became so unmanageable that we actually approached our publisher and said, did you want to think about maybe a loose leaf service? Because it's completely off the charts. So that's how much attention judges are now paying. And of course, once judges and arbitrators and human rights tribunals start paying attention, we really start to learn a lot more about what's expected. It's been gratifying for us, because I think for many years we've been talking about best practices and the kinds of things that investigations should include. And as I mentioned, even with sharing allegations with the respondents, that hasn't always been universally endorsed. So it's been nice to see judges saying, yes, of course, you must do these things. That's what a fair, thorough process looks like. So just a sampling. This was a case out of Calgary back in 2013. A complainant who had been sexually assaulted numerous times by her supervisor. And she'd actually gone so far, because she was finding it so frustrating that her employer wasn't addressing it, she'd gone so far as to install a spy camera at her workstation in order to try to catch this behavior, which she did on tape. She brought it to the attention of her employer, and they just basically said it was inconclusive. And the respondent was suspended. They launched an investigation, but they didn't fully investigate. And once the investigation started, the complainant came in and she found rat poison on her desk. And so then she was relocated. A month later, the investigation still wasn't completed, and she was told at that point to return to the workplace. Then she took a vacation, and she was asked to provide a fitness to return certificate, even though she wasn't sick. So it was just as though they really didn't know what they were doing. And ultimately, she grieved. She went on sick leave and grieved. And the arbitration panel held that the city had to pay her $800,000 in damages after it was found that they had mismanaged the complaint. So this is huge for an arbitration decision, particularly flowing specifically out of the nature of the handling of the complaint and the investigation. And specifically the things that they commented on in the case. So the fact that the manager didn't investigate immediately, timeliness in these cases is so important. And it's one of the things that when we go in and we train in organizations people how to do investigations, we're really explicit about this. You know, we understand that you've got all kinds of things on your desk. And, you know, often we're talking to the HR team. So the HR team, they kind of get it. But if anybody else is doing an investigation, like a manager, frontline manager, they don't necessarily have any sense of the importance of the process and the fact that these other things that are competing for their time have to take a back seat and they have to focus on this investigation. So it didn't start immediately. The manager actually went on vacation and left the alleged respondent in charge after the complaint had been filed. The manager did not adequately assess the spy camera photos before concluding that the evidence was inconclusive. They didn't remove the complainant from the workplace, so after the complaint was filed, and this is always, it's a little bit of a slippery slope, right? Because there are complainants who, if you attempt to simply remove them from the workplace in response to filing a complaint, it may feel like a reprisal. You know, why am I not being able to work? Why isn't the respondent? Or even if both people are sent home, well, why am I being punished, right? They're the one who engaged in the bad behavior. So that does have to be managed carefully, but in this case, the complainant felt like she was being forced to work when she didn't want to. Failed to complete the investigation of allegations and the poison incident. Warned the employee about being disrespectful, but didn't investigate her complaint. And then they commented on the requesting the return to work, the fitness to return to work note. So a really dramatic example of an investigation gone wrong, and one of an increasing number that we're seeing. Walmart. So, and like not unsophisticated employers, right? City of Calgary, Walmart. So in this case, Ms. Bouchet worked at a Walmart facility, so she wasn't at head office, she was at a facility. She had been asked by her store manager to falsify some records associated with the refrigeration unit, and she refused. And when she refused, she was, from that point on, bullied, harassed. Partly, it was sort of a weird love-hate thing, so there was a sexualized element to it, but then it was really quite non-sexually abusive as well. So she complained, and in fact, when she complained, Walmart said, okay, fine, we'll investigate, but if we find that this didn't happen, we're going to discipline you. And so she was threatened with discipline for having brought the complaint. They did an investigation, which ultimately was deemed to be inadequate, but found that the allegations were unsubstantiated, and so, of course, the harassment continued. She quit and sued. This was a lawsuit. Walmart was ordered to pay her damages, and the only damages we've mentioned here are one category of damages. So this was just the aggravated damages claim. There was also a punitive damages award and a wrongful constructive type dismissal award. The other interesting thing about this case is that this was a jury trial. So, and that's not always common knowledge, but you can actually request a jury in even a civil trial. It's ultimately the plaintiff who gets to decide whether their case is going to be heard by judge or jury. So she chose, smartly, a jury, and the case actually went up to the Court of Appeal because the jury granted an award that was so kind of off the charts that the Court of Appeal had to rein it in a little bit, which is what they do. Suffice it to say, though, the aggravated damages award stood. It was the punitive damages award that was reduced. And why they awarded it was, again, directly related to the inadequate investigation. So they didn't take steps to bring the supervisor's misconduct to an end, didn't take her complaints seriously, finding them unsubstantiated, despite, and so this is a common theme as well, that, again, people who do investigations internally don't always have the expertise to do them, so they don't necessarily know who to talk to, whether to talk to particular people. They just ignore what is ultimately relevant evidence and make these findings when in fact the findings are incorrect, because had the other evidence been pursued, it would have been a different finding. So it didn't meet with many witnesses who observed the incidents, failed to enforce workplace policies. They commented on the fact that she'd been threatened with retaliatory behavior just for making her complaint, which is not appropriate. And then issues around returning her to work, ultimately forcing her to resign. So the last one I'll just mention, and we're sort of covering all the bases. So grievance, arbitration context, court case, human rights tribunal, which is probably 3 of the potential 4 avenues now that we might see, the 4th one being in Ontario, the Ministry of Labour, and I'll talk about that in a minute. But up until now, in terms of harassment, being on the receiving end of harassment, people have the option to go to the Human Rights Commission if the harassment that they've been subjected to relates to a human rights ground, which in this case it did. There were 2 separate allegations. One was racially related, the other one was disability related. So Mr. Sears complained that his coworkers had made various inappropriate comments to him and some inappropriate gestures that were related to both of those things. And he complained that the company, Honda, hadn't properly accommodated him or addressed his complaints. They did investigate in this case, but again, the investigation logic or the analysis that was applied wasn't appropriate. So again, discounted certain witnesses, didn't pursue evidence that was available to prove certain of the allegations. And then an interesting thing in this case was that they actually applied the wrong legal standard, the investigators. And people forget that, but ultimately if you're having to make a finding, we read reports a lot of times where people say, here's the evidence, and it's harassment. And they leave out the middle part, which is, okay, well, how did you get from point A to point B? There must have been some analysis that you did. I mean, obviously some things are glaringly harassment, but sometimes it's far more subtle, and you have to look at the language in a policy and connect the dots as a decision maker. So this didn't happen, and in fact, once the analysis got unpacked, it was clear that the investigator had not really applied the appropriate legal standard, hadn't relied on evidence that they should have to draw a different conclusion. And then they just didn't even investigate allegations that he'd made about a failure to accommodate. So in this case, again, tribunal picks up on those things. The award here was $35,000 in general damages. So not $800,000, not $200,000, but in a particular case, this can be an appropriate format. Now, this case actually preceded another one, which was in 2015, involving some temporary foreign workers. And I don't know if you heard about that case in the news, but it involved really serious allegations of sexual harassment by, lo and behold, the owner of the business. Who was bringing in these workers from Mexico. And so they didn't speak English. He would take their passports, and they lived on site or in accommodation that the organization found for them. So like the most vulnerable employees you can imagine, and he would sexually harass them and threaten to send them back to Mexico if they didn't comply. So in that case, the Human Rights Tribunal, this was a large award in 2014 when it was made, but in that case, there were 2 complainants, and one of them was awarded $150,000 in general damages, which was the most, by far, the highest award the Human Rights Tribunal had ever made in a sexual harassment case, if any case. And the other complainant was awarded $50,000. So you can even see within the last couple of years a bit of a shift to really signal how much more seriously decision makers are taking this kind of behavior. All right, so a bit of a sea change in Ontario on the sexual harassment front. September 8th of this year, the Ontario government had enacted, it came into effect in September, legislation changing to some degree the landscape for employers around investigations of harassment in the workplace. So what has changed? In 2010, the Ontario government amended the Occupational Health and Safety Act, and at that time, what they did was they put in place some changes which required employers to have policies which the big impetus behind the change in 2010 was workplace violence. So you may recall that there were all kinds of changes associated with making sure organizations did risk assessments and had violence policies and programs to address violence in the workplace. But the add-on, that makes it sound less significant than it was. It was significant because there was, for sure at that point, understood to be a relationship between violence that had been occurring in the workplace and issues of harassment that often underpinned them. So there was an add-on for a requirement that organizations put policies in place to deal with workplace harassment. And the change was, you know, we'd had law addressing workplace harassment, but it had to be human rights related. So for anything that didn't have a human rights edge to it, there wasn't statutory protection. So now we had statutory sort of protection, insofar as organizations had to have policies and procedures that talked about how they would investigate complaints. That's all we had. So if you had a problem and you complained about it to the ministry said, does your organization have a policy? And if they did, that was all that had happened. So not particularly effective in terms of enforcement. So I think there was a fairly early recognition that more needed to be done, and that is really what this legislation was intended to do, is fill some of those gaps. So now, what organizations are required to do by statute in Ontario is to investigate. Before, you just had to have a policy saying that you would investigate. Now you actually have to do it. And what's interesting about this language is that it says that an investigation has to be conducted into not just complaints, right? Complaints we get. People fill out forms, they, you know, come forward with kind of capital C complaints. But the language they chose was really deliberate. Incidents and complaints. The earlier legislation had used the same language, but where it really takes on significance is when there's a requirement to investigate both of those things. So what does that mean? Complaints, again, we understand complaints, but what we also understand, for those of us that do work in this area, is that there's an extraordinary amount of behavior about which people do not complain. And frankly, that organizations know or suspect is happening. So often those are incidents, which means organizations wonder, well, how are we supposed to investigate incidents? So first we have to understand what they are. The ministry's released a code of practice to accompany the legislation, which is quite comprehensive and mostly helpful. I would probably say that in some respects they've gone perhaps a little far, not surprising. So I wouldn't take it for gospel, but certainly if you're looking to get a guide or a sense of what the ministry would ideally be looking for, it's a great comprehensive tool. So according to the code, if we're talking about incidents, the employer has to ensure that an investigation appropriate in the circumstances, and again we'll talk about what that means, is conducted when. So if you look at number 2, obviously when a complaint, written or verbal, of workplace harassment is made. And verbal is important because, again, we have clients, we've seen employers who say, well, until they put it in writing, it's not really a complaint. So now statutorily, yes, it is. It is a complaint. But more importantly, when the employer or a supervisor becomes aware of the incident of workplace harassment by the worker who experienced it or another worker. So that's a huge catchment piece, right? You can think of all kinds of ways that information could potentially come to organizations, and more importantly, people within organizations. I mean, this is really the challenge. We'll often get retained by organizations to both investigate the complaint or the issue, but also because one of the things that's been alleged is that someone in the organization knew about it and didn't do anything about it. So, and then of course what gets revealed is, yeah, somebody did know about it and didn't do anything about it. So that's a real learning for the organization, is that we have to figure out how to better educate our people when this information comes forward. So that was the case pre-Bill 132. Now I would say you've got a statutory obligation to both make sure by statute that those people who might get that information bring it forward, because you have a duty to investigate it. But we also know that there's a training obligation under Bill 132, so to get that information out to the people who need to know it. Not necessarily unique to Ontario either, for those of you who may be from other jurisdictions. BC has something similar in their guide. They have a policy, comes up under their Workers' Compensation Act. They've got a workplace bullying and harassment policy, and you'll see within it, they talk about employers being expected to develop and implement procedures for how the employer will deal with incidents or complaints. So again, that's language that we're seeing more often. Yeah.
In the Ontario Act that you talked about earlier, are there provisions for the use of ADR for legal investigation?
There are, so I'll get to that. Yeah, there's a provision for some use of ADR. Yes, bear with me. All right, so we don't, is early days, right? We're just sort of a month and a half into Bill 132. We'll learn more as things progress, but for our purposes, because this for us was not news, we'd been telling clients this forever, that they couldn't ignore information that came forward, that basically, the analogy that we always used was it's a hot potato. So we don't care if it comes in a gift-wrapped complaint bow. If you have a hot potato, if someone's come to you with information suggesting that if it's true, there's harassment occurring with your organization, you have to do something with it. Otherwise, you know, you're going to be the organization that knew about it and did nothing, and we see how that plays out. So these are the different ways that that information can come forward. And so one of the takeaways, again, you know, for organizations when we talk to them is, you know, think about who might get this information in your organization and make sure they know. They know what kinds of things can come to them. They know what to do when it comes to them. They don't have to solve it, but you have to have some mechanism for them to know who to bring it to when it comes to, so they don't ignore it or they don't make it worse. So whether that's you know, somebody coming forward saying, I don't want you to do anything about this, I just thought you should know. It could be exit interviews, employee engagement surveys, performance reviews, you know, all these kind of innocuous ways that that information might come forward where it might not necessarily on first level get to the people who would know what to do with it. So thinking about that. Yeah, Rick?
Yeah, we see a lot of that comes out of workplace assessments, and a lot
Sure.
of times the thing that causes them to initiate an assessment is there a way we can create a safe environment where something like this, if it's there, will surface?
Right. Yeah, beauty of an assessment. And that, so it raises a great point, which is what does appropriate in the circumstances mean? So if we know under Bill 132 that the obligation is to conduct an appropriate investigation, one of the first questions people had when they saw the draft legislation was, well, how do we investigate if we don't have a complaint? Because then we don't have a complainant. And so your point is such a good one, which is, you know, particularly ADR, you know, professionals have all these tools. So we can talk to you about an assessment or an employee engagement survey or some other thing that we can do that's going to allow that information to come forward if it exists. You know, maybe if it was just a rumor, what we find out is that there was really nothing there. So that's great. We've looked into it. We've fulfilled our statutory duty, but we didn't have to go in and do a full-blown investigation.
Can I ask you a question about what we sometimes experience are clients who kind of want to get both things at once. They want you to do a workplace assessment, but what they really want is they want the outcome of an investigation.
Right.
But they want you to do the surfacing using a workplace assessment, which means you basically reassure everybody it's a without prejudice process, blah, blah, blah.
Yeah.
But it isn't really a without prejudice process because what the employer wants is they want a with prejudice outcome.
Right.
How do you guys deal with that?
Yeah, we do, and it's a great point you make, because if anyone in the room has worked on both of those processes and hasn't encountered that, it will happen to you, and I think you do have to navigate that, protecting your reputation as a professional, because you can't be asked to meld two processes. Those two processes, assessment versus investigation, are very different. In an investigation, people have certain rights and protections that are continually being better described, better articulated by courts and tribunals. And if you just sort of put all those aside and proceed with an assessment and then attempt to make a decision at the end that is counter or against someone, I think you run a real risk of having someone come back, you know, bring some kind of a legal claim and find you to be responsible for that. So I think you really have to watch, make sure you understand your processes. And if it means hard discussions and, you know, lines in the sand with your client, then so be it. You're really protecting them too, because a claim's not just going to be against you, it's absolutely going to be against them too. Yeah, yeah.
So you have a typical timeline between the moment a complaint is brought forward and to conclusion?
Okay, well, I told you about the case that I've been working on since last July. That would not be typical. But I think it underscores the point that there really isn't anything typical. It so much depends, and you know, anybody who does investigations, I'm sure you get this question at the beginning, how much will it cost and how long will it take? And you laugh, right? Because, okay, who knows how long and who knows how much? Because it may look like this today, and a week from now it may look completely different. So I don't want to tell you something and then have it change into something completely different. The good news is that I think the more you do, the more things you can use to inform a best guess. So 2 parties as opposed to multiple parties, few allegations as opposed to many allegations, parties that are, you know, the allegations are not that serious, they're not represented by lawyers or by their union. Those are all things that remove elements of complexity and will probably mean a shorter process.
I've seen union situations where they go on to 5, 6, 7 years.
Yeah, so exactly. You know, what guides us is that we are constantly, as the investigator, asking ourselves at every step of the way, if someone were to lay out everything I did on a timeline, could I justify how long this took and why? Is there an explanation and a justification, or is it going to look like I wasn't giving it my attention? Because if I can't do that, I have to recognize I could be sitting on a stand one day testifying because someone's brought a claim alleging that this process was invalid because of how long it took. And will I be able to justify every delay for some valid reason? So I think if you can't do that, and I think whether it's as the investigator or whether it's as the client, you both have to be working actively to make sure that you've got that defense. Yeah. Okay. So similarly, we've got language also in BC that talks about appropriate in the circumstances. Here they specifically say, and I like this because this is even broader than I think Ontario has done yet. So they talk about an appropriate investigation or a process being providing direction and supervision to affected workers, providing specific training, imposing workplace arrangements. So you're really seeing that we're not terribly confined, at least not yet, to what's meant by an investigation. All right, just the last thing on the law. What is interesting is that there is an enforcement mechanism now. So what Bill 132 has said is that if the ministry is not satisfied, if a complaint is lodged about an investigation or lack of an investigation, the ministry can actually order that the employer do an investigation, potentially do a second investigation, and that someone external, an impartial person who is trained, who possesses the knowledge to do it, comes in and does it, and that expense, the expense both associated with the investigation and also the expense associated with writing a report will be the employer's expense. So we'll see how often and when, in what circumstances that's used. But ideally, you're doing the processes well and then avoiding that order. So more to come on that. All right. So just in our last few minutes, I wanted to spend a bit of time to, oh yeah, sorry, Gary?
Quick question.
Yeah.
Aside from Ontario, and I'm familiar with BC, any other provinces or federal jurisdiction have anything resembling 168 or 138?
Nothing. So I won't say not resembling Bill 168, because I would say Quebec was probably the pioneer on legislation around workplace harassment. So there they do have a whole mechanism. I don't believe it's that robust as far as investigations are concerned, although my guess is it's probably more similar to the Human Rights Tribunal, where there's a deference if an investigation's been done and it seems reasonable. But beyond that, no. Certainly, you know, starting to see smatterings of legislation around what is harassment in some occupational health and safety legislation, but not around investigations. Yeah, yeah. I guess nothing prevents it. I will say, I think virtually every policy contains language which makes clear that people who bring those kinds of complaints are subjected to discipline if they do so. And I'll just comment anecdotally, you know, in 20 years of doing this, 20 plus years of doing it, I can, hundreds and hundreds of investigations, and I can count on less than 3 occasions have I seen examples of where I thought somebody had brought a bad faith complaint, and I've only once made that finding. I think for the most part, it's not worth it. You know, people complain because they really think something's happened to them. And I'll draw a distinction, because there are a lot of people who think things have happened to them and they didn't really happen. So, and that, for me, that feels like a frivolous complaint to the person who's accused, but it's not frivolous, because for whatever the reason is, you know, they've kind of rewritten their own history, they may have mental health issues at play, they believe it happened. So that, for me, that's not a frivolous complaint. Yeah.
A related question, what if two or more employees agree together to get rid of a particular employee or supervisor?
Yeah.
And then they sort out their stories to make this happen, and only have this questions?
Yeah, it can happen. Again, I think people expect it happens a lot more often than it does. People believe it well, I won't say people believe it. A lot of respondents who are guilty of bad behavior say that that's what's happened. So we hear that allegation a lot, but it's quite easy to disprove. You know, the reality is, if you're an experienced investigator and you meet with people, even if the suggestion is, oh, it's a conspiracy, they're all colluding, you know, you meet with people, you hear their stories, you can tell for the most part if they're telling the truth or they're all saying the same things. You know, when they say the same things, they tend to use the same language, they tend to tell the story in the same way, and the people who have genuine evidence that supports a claim, they tell their story and it sounds authentic. Yeah. Okay. All right. Yeah, so sorry.
Those 2 words, evidence and stories.
Yeah.
Very different things to me.
They are.
So do you ever take testimony under oath?
I don't. But it.
Why not? That is a perfect example of where, you know, it might prevent people from conspiring. Is there a reason why you don't?
I mean, I think it's not a judicial proceeding, so.
And it's not evidence.
Well, it's the information upon which I rely to make a decision. So I certainly ask people at the outset of an interview to be honest. So for me, what's the difference, right? If you swear an oath, you tell me you're going to tell me the truth, you're either going to lie in both circumstances or you're going to be inclined to tell the truth. Is it really going to make a difference, one or the other?
I think it does.
Yeah, to respond to this question.
Do-
One's reputation can be marred without just cause. And I think it's a fine line to cross. And I think the nurses evidentially, it can be very damaging to the respondent, because it can happen where it's been false accusations. It's very hard to get back that person's reputation and name.
Right. Well, I mean, if we compare it to judicial proceedings, people can affirm that they're going to tell the truth, which in effect they do when I tell them that I expect them to tell the truth and they agree to do so. So, you know, whether they're swearing it to their God or agreeing to tell me the truth, I think the legal effect of that is the same. Well, I can't, in a workplace investigation, we don't have the legal capacity to make that a criminal code offense. I mean, that's not what workplace investigation, they aren't criminal proceedings. And we can't even compare them to criminal proceedings because they're not, ultimately, the end result is not somebody going to jail.
Decision based
Yes.
on things that have been told to you.
I'll tell you what, so why don't we take that offline, just because I'm conscious of the fact that we've got limited time left and I just want to cover the conclusion of the presentation. So just thinking about the ways in which ADR can ultimately touch on, or investigations could touch on ADR, how they might intersect. So before the investigation, certainly lots of benefits to early ADR as an alternative to investigations. I think just in talking about the process as we understand it of an investigation, the distinction between coming up with an ultimate decision that finds in favor of one party or the other, it's really more akin to a judicial decision. And, you know, people in this room know better than anybody all the reasons why mediation or any other form of ADR is preferable to that. So less adversarial, far greater probability of workplace restoration. You know, we certainly can see that at the end of an investigation, it's been hugely impactful on the parties. They certainly become, I think we used the term in our discussion, it can feel adversarial. It becomes quite polarizing. So if there's any opportunity before or instead of going down that path to try to otherwise resolve it, it's worth pursuing. The investigation is right for some cases, for sure, but absolutely lots of cases where it's not an optimal solution. So during the investigation, you know, we tend to talk about the distinction between formal investigations. This one we talk about do investigation training. We talk about everything that is not formal. So formal is the traditional process that we've talked about where there's kind of a beginning and an end. There are interviews, there is decision making, and then a report that articulates that decision. Anything else that isn't that we call informal. And it's not always an exact science where you can look at a case at the beginning and say, well, this one should be formal and this one should not be formal. But we've tended over time to see certain cases lend themselves better to formal investigations versus informal. And this is just this is not an exhaustive list, and it's not by any means perfect. You're going to have cases where you've, I'm sure, informally done mediation or ADR in these circumstances. But, you know, in High Five, for example, you can see some benefits to doing an investigation. On the other hand, you take things like high stakes, high profile, you might absolutely want to try to mediate that and keep that out of the public eye, lest an investigation go public. Formal investigations where you've got a recurring problem, so it may be that you've tried ADR in the past and it hasn't been successful. Power imbalance, so if people don't buy into an ADR process because they just feel that the stakes aren't fair or even. Sometimes you need to head down the investigation path just because there's more information that you need to inform an ADR process. Or maybe you need some kind of special expertise if there's power imbalance or high-profile people. Allegations are serious. Sometimes you just know that based on what's at stake, you're not going to be able to sort this out short of somebody proving that something occurred or didn't, or a finding to that effect. Inarticulate complainants, so we find sometimes they aren't as embracing of an ADR process, and respondents who don't take it seriously. So those are just some examples of some of the dynamics that might suggest formal. Downsides, obviously more costly, more time intensive, potential chill on just the impact on the workplace as they're occurring, and then the impact on relationships going forward. So where you might do something less formal or more ADR oriented, when the allegations are less serious, so maybe it's a miscommunication, people are on the same footing, situation doesn't really require any additional information, issues minor. Again, not an exhaustive list, but a sense. So just the last caution here, and has anybody heard of this case? It came out about a month ago, and it involved a mediator, actually, who did an investigation for the Attorney General's office. And it was a fairly serious complaint, but what was unique about it, which I think should have really been a heads up, was that the individual respondent was very highly placed within the organization. And ultimately, the mediator found that the allegations were substantiated, and as a result, the respondent's appointment was revoked, and it became quite high profile. The court ultimately the respondent brought a claim against the organization, and the investigation that the mediator did became very much the subject of the decision. And what the court found was that the investigator went in, did not maintain objectivity, pursued and commented on the issues that were beyond the scope of the mandate. And again, without having done investigations, this is such an easy trap to fall into. There were just things that kind of caught her attention and took her off on tangents, and also kind of drew her into drawing certain conclusions about who the respondent was that were very hard to substantiate ultimately when the case went to court. She didn't properly review all the evidence. She didn't go down all the evidentiary paths that she should. She accepted the complainant's evidence about the emails and discounted that of the respondent. And again, there was really no justification for having done so. So it was that analysis piece that was missing from her report. And she changed some of the wording in the report, and she destroyed her handwritten notes of her interviews. So the court was just all over this and really slammed the mediator in the decision. And so really, a good cautionary tale about this. If you haven't taken anything away from this discussion today, to kind of dabble in this area can be fraught today without really having a good sense of how critically these cases do get reviewed now by courts and the kinds of cases that can ultimately come forward. Yeah, Rick?
Can I just ask you, when it says that change some of the wording in the report, like between when and when, between a draft report and a final report?
Yeah.
Was there a reasonable reason for that? 'Cause
No.
sometimes there's a reasonable reason.
No, and I think if there was a reasonable reason, they wouldn't have criticized for it. And it comes up, I know we have extensive discussions in our office when we get asked by clients to change things. Are we going to do it? If we do it, if we get cross-examined on this, how will we justify it? Can we justify it? And sometimes we'll agree and satisfy ourselves that it's reasonable. And other cases we'll refuse because we won't be able to justify that. All right. And then, so after the investigation, all kinds of ways that I think ADR can be used to try to repair a broken workplace. And the one thing that I'll just, I don't know what happened to that weird thing there. So the Ministry of Labor has included some language in their guide. So it's not in the legislation under Bill 132, but in the guide they've talked about ADR cannot replace the investigation. So that's an important understanding. So that's at least where we understand the ministry is coming from, that they're not saying if there is a duty to investigate, ADR can't be used as a substitute. However, if the parties agree, ADR can form part of the resolution to the complaint after the investigation is completed. Now, again, all we know is that investigations have to be appropriate. So it might mean that if the parties agree to some form of ADR, the appropriate investigation would be very limited, very low level, something that would nicely complement an ADR process. But until we learn more, and that's not law, that's in the guide. So we've got a lot to learn to see how ultimately the ministry is going to interpret that. All right, so there we are. If you are interested in staying abreast of developments in workplace investigation, please don't hesitate to leave me your business card, because we put out regular newsletters on the subject, updating on cases and legislative developments, so happy to have you included there. I'll hang around for a bit, so if you have any other questions, feel free to bring them up, and thank you so much.